This gets into the dynamics of everything with Lafayette County and the state of Mississippi, the actual pure negligence, the culpable negligence, and the recklessness of everything. The Fourth Amendment, incorporated to apply to the states through the 14th Amendment, Baker v. McCollum, protects individuals against unreasonable seizures. U.S. Constitution, Amendment 4. Because they involve unreasonable seizures, constitutional claims for false arrest against state public officials arise under the Fourth Amendment. See Carter v. Butts County. An arrest is a seizure. Claims of overdetention under 1983, 42 U.S. Code 1983. Claims of overdetention can arise under the Fourth Amendment's right to be free from detention without probable cause, or under the 14th Amendment's substantive due process right to be free from continued detention after it should have been known that the detainee was entitled to release. See at 952, also see Cannon v. Macon County. Proving a violation requires a plaintiff to establish that the defendant was deliberately indifferent to his due process rights. I think I've proven that there's been a deliberate indifference since day one. To satisfy that standard, a plaintiff must show three things. One, the defendant's subjective knowledge of a risk of serious harm in the form of continued detention even after the plaintiff had a right to be released. Two, disregard of that risk. And three, disregard by conduct that is more than mere negligence. So what I would like to say on that is that he's now I think a captain. Jared Bundren, his failure to take any steps to properly investigate and identify the claims made on affidavit to be grotesquely false in nature is sufficient to raise a question of fact as to his deliberate indifference towards Reardon's due process rights. Numerous courts have also reached the almost tautological conclusion that an individual in custody has a constitutional right to be released from confinement after it was or should have been known that the detainee was entitled to release. This is their job. They're supposed to know this, especially when it comes to the liberties and the freedoms of assumably innocent American citizens. Depending on what procedures the state affords defendants following arrest and prior to actual trial, mere detention pursuant to a valid warrant, but in the face of repeated protest of innocence, will, after the lapse of a certain amount of time, deprive the accused of liberty. Now, without due process of law. Question is, what is that certain amount of time? I sat in jail for 6 weeks' time. 3 manifest errors, actually more than 3. I should have been released no more than 14 days in. I should have gotten an initial hearing within the first 48 hours. A refusal to legislate equally for the protection of all would unquestionably be a denial of equal protection. This conceded, upon what ground can it be pretended that a refusal to execute or a failure to do so through inability, equally with reference to all persons, is not also a denial? I maintain, therefore, that the true meaning of this constitutional provision is that the state shall afford equal protection to all persons within its jurisdiction. Failing to do this, whether that failure is the result of inaction or inability on the part of the one or the other of the coordinate branches of the state government, the remedy lies with Congress. Whenever it appears that any state has failed to discharge this high constitutional obligation to all its citizens, it is not only within the power, but it is the solemn duty of Congress to enforce the protection which the state withholds. And that right there is my justification. It's the reason why I've called multiple congressmen and senators, and I have demanded that this particular fiasco is required of a congressional inquiry, congressional oversight. There needs to be a congressional hearing. There needs to be a congressional hearing on everything. Congress enacted the predecessor of Title 42 U.S. Code 1985, which prohibited private conspiratorial conduct. Congress recognized that men who go undisguised upon the public highway or upon the premises of another are not likely to be acting in official capacities. The 42nd Congress believed it had both the constitutional power and the obligation to prevent private conduct from interfering with the guarantees of the 14th Amendment, United States v. Williams, cited in Griffin v. Breckinridge. Griffin v. Breckinridge, the court articulated a clear position that Section 1985, Paragraph 3, was a remedial statute that was constitutional on its face and that reached private conspiracies to deprive citizens of civil rights. The court stated that 1985, Paragraph 3, reaches private conspiracies to deprive others of legal rights can, of itself, cause no doubts of its constitutionality. Thus, according to Griffin, state action is not required in order to bring a suit under Section 1985. Yet, if the constitutional right that is violated is the right to equal protection of the laws, Section 1 of the 14th Amendment indicates that those rights are violated only if a state shall make or enforce any law which denies to any person within its jurisdiction the equal protection of the laws. Through this reasoning and interpretation, the state must be involved in order to find a 14th Amendment violation. As such, plaintiff brings forward his claims against the state of Mississippi and each official named within for their full knowledge of aggrieved violations. Lafayette County, Mississippi, and its officials named within for their full knowledge of aggrieved violations. And plaintiff alleges that the defendants conspired upon efforts with certain individual private citizens to hinder the plaintiff's right to vindication through the intentional initiation of frivolous and knowingly perjurious legal proceedings, and further refusing him the equal protections of the laws guaranteed under the 14th Amendment. In turn, the state of Mississippi, through denying the plaintiff the equal protections of not only its own laws laid out, but federal constitutional rights as well, have continued to deny plaintiffs absolute right to redress and vindication. Plaintiff alleges that there exist multiple examples of this now, and that evidence would demonstrate a continued repetitive effort that the state of Mississippi, and in particular Lafayette County and Lafayette County Sheriffs Department, have demonstrated an undeniable pattern of the same occurrences and conduct, leading directly to an ultimate end goal of the defendants absconding with their prior immoral, unlawful, and unconstitutional acts, further intending to seek indemnification for intentional liabilities by inflicting fear and pressure into the plaintiff so that he caves and gives in. It's the continuation of the latter that plaintiff alleges constitutes violations under the RICO Act, and as such, plaintiff alleges RICO Act violations in his complaint. Now, I'd like to flip over. The Mississippi Bill of Rights consists of 29 sections. Now, there have been some that have been repealed. This is how I think that everything applies. I'm going to wrap everything together with this right here. You have Article 3, Section 5, and that is government originating in the people. All political power is vested in and derived from the people. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. We have Section 6, regulation of government, right to alter. The people of this state have the inherent, sole, and exclusive right to regulate the internal government and police thereof, and to alter and abolish their constitution and form of government whenever they deem it necessary to their safety and happiness, provided such change be not repugnant to the Constitution of the United States. Section 8. Citizens of state. All persons resident in the state, citizens of the United States, are hereby declared citizens of the state of Mississippi. That is important for one of the ones to come. That is important for establishing that I'm a citizen of the state of Mississippi. Section 11. The peaceful assemblage, right to petition the government. The right of the people peaceably to assemble and petition the government on any subject shall never be impaired. The right of the people peaceably to assemble and petition the government on any subject shall never be impaired. That's Article 3, Section 11 of the Mississippi Constitution. So not only when I was out in front of the statue by myself, not causing any issues, was that highly unconstitutional, both on a federal level and a state level. Section 12, the right to bear arms. The right of every citizen to keep and bear arms in defense of his home, person, or property, or in aid of the civil power, when therefore legally summoned, shall not be called into question, but the legislature may regulate or forbid carrying concealed weapons. I didn't carry concealed. Section 14, Article 3, Section 14 is due process. No person shall be deprived of life, liberty, or property except by due process of law. Section 15, and I think this is a very interesting one that I believe I can certainly make apply as well, particularly when it comes to the banishment that they imposed. The covenant to not sue, mainly the banishment. Slavery, involuntary servitude prohibited, punishment for crime. There shall be neither slavery nor involuntary servitude in this state, otherwise than in the punishment of crime, whereof the parties shall have been duly convicted. Section 16, ex post facto laws, impairment of contract. Ex post facto laws or laws impairing the obligation of contract shall not be passed. Section 17, taking property for public use, due compensation. Private property shall not be taken or damaged for public use except on due compensation being first made to the owner or owners thereof, in a manner to be prescribed by law. Whenever an attempt is made to take private property for a use alleged to be public, the question whether the contemplated use be public shall be a judicial question, and as such determined without regard to legislative assertion that the use is public. Section 20 is an interesting one that I think applies to Lafayette County as well. Specific term of office. No person shall be elected or appointed to office in this state for life or during good behavior, but the term of all officers shall be for some specified period. Section 21. Writ of habeas corpus. The privilege of the writ of habeas corpus shall not be suspended unless when in the case of rebellion or invasion the public safety may require it, nor ever without the authority of the legislature. Section 23. Searches and seizures. People shall be secure in their persons, houses, and possessions from unreasonable seizure or search. No warrant shall be issued without probable cause, supported by oath or affirmation, specifically designating the place to be searched and the person or thing to be seized. Section 24 is a big one. Open courts, remedy for injury. All courts shall be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law. and right and justice shall be administered without sale, denial, or delay. Section 25 is the access to courts. No person shall be debarred from prosecuting or defending any civil cause for or against him or herself before any tribunal in the state, by him or herself or counsel or both. Under Section 16, the ex post facto laws, impairment of contract. Laws impairing the obligation of contract shall not be passed. I think that a contract is in the form of the Bill of Rights. That's a contract the state makes to each citizen, guaranteeing those rights. And the fact that pursuant to the Mississippi Bill of Rights and Section 25, Article 3, no person shall be debarred from prosecuting or defending any civil cause or against him or herself before any tribunal in the state, by him or herself or counsel or both. Okay, so that covenant to not sue that I was pressured into signing to get my freedom was a violation of state law and federal law. Section 26. Rights of accused. State grand jury proceedings. In all criminal prosecutions, the accused shall have a right to be heard by himself or counsel, or both, to demand the nature and cause of the accusation, to be confronted by the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and in all prosecutions by indictment or information, a speedy and public trial by an impartial jury of the county where the offense was committed, and he shall not be compelled to give evidence against himself. Section 27. Proceeding by indictment or information. No person shall, for any indictable offense, be proceeded against criminally by information except in cases arising in the land or naval forces or the military when in actual service or by leave of the court for misdemeanor in office, or where a defendant represented by counsel has, by sworn statement, waives indictment. But the legislature, in cases not punishable by death or by imprisonment in the penitentiary, may dispense with the inquest of the grand jury and may authorize prosecutions before justice court judges or such other inferior court or courts as may be established in the proceedings in such cases.